What is a default termination? What are the consequences of a default termination? And how do you avoid one? The default termination is when a contractor's contract is ended by the federal government, by an owner, by a prime contractor, based on a failure to meet a contract term or an anticipated failure to meet that contract term. In order for the termination to be appropriate, that term must be both material, sometimes called the essence of the contract, and it must be something that can't be fixed, something that cannot be cured. What are the consequences of this? Well, for the terminated contractor, the consequences are immense. First, from a financial standpoint, the contractor might be responsible to finish the contract with their own money, sometimes called reprocurement costs. But even more significant, that contractor is going to suffer tremendous reputational harm. Sometimes we refer to this as a death sentence for contractors, because federal contractors, at least, have their performance evaluated and tracked. What are the consequences for the federal government? Very little. Because the federal government always has the right to terminate a contractor for its own convenience. Anytime the federal government makes a mistake and terminates a contractor for default or purports to do that, and it turns out the contractor shouldn't have been terminated, that termination is simply converted to one for the government's own convenience. And while the contractor gets some additional money, there's no real downside for the federal government. So how does a contractor avoid a default termination? Document, document, document. First, you always want to demonstrate, if you're a contractor being accused of a breach, that the reason you're not complying with the contract is not your fault. Second, you always want to demonstrate a plan for fixing any breach, demonstrating that you can cure the breach. And third, you actually want to go ahead and prove that you have cured the breach. At this point, you want to avoid a dispute about who should pay for the extra effort it takes to cure that breach. Sometimes contractors and owners get into a debate about whether the efforts are an acceleration effort because the contractor is being asked to do more than it thinks it has to do, or it's simply a recovery effort. The contractor is meeting its plan to cure that breach. Don't have that fight now, solve the problem, and then argue about money later.